Ochsner urges this court to answer this question yes, and to hold that the Public Records Act of Chapter 132 does in fact apply to Elon Campus Police, such that Ochsner's complaint alleging the failure to disclose public records pled a claim for which relief may be granted, thereby making the decision below affirming the dismissal of Ochsner's complaint in error and requiring reversal. At this time, I would like to reserve 3 minutes of my time for rebuttal and the last 5 minutes of my pre-rebuttal time for Ms. Martin. This case arises from a public records request that was made by Ochsner in March of 2010 to the Elon Campus Police for records related to the arrest of an Elon student, Stephen Connors. When Ochsner made the request, he was a reporter for the Elon University's news program, Phoenix 14 News. Ochsner learned that during the early morning hours of March 5, 2010, Officer Joshua Tillotson of the Elon Campus Police Department effected the arrest of Connors, charging Connors with 2 misdemeanors: underage consumption of an alcoholic beverage and the resist, delay, or obstruct a public officer. Ochsner contends that in response to his public records request, he was provided with some but not all of the information and or documents in Elon Campus Police's possession. Litigation ensued. As I indicated earlier, the core issue before this court is to determine whether the Public Records Act of Chapter 132 applies to the Elon University Campus Police, and if so, whether all of the public information and or public records in its possession were made available for inspection to Ochsner. The decision below is in error and requires reversal for 2 main reasons. First, the decision below is directly contrary to the framework set forth in Chapter 132 by concluding that the Act does not apply to Elon Campus Police because it is not a public law enforcement agency. And second, the court below failed to follow long-standing rules of statutory interpretation by reading portions of the definition of public law enforcement agency found in 132-1.4b3 in isolation and in such a manner so as to render part of the definition without meaning, neither of which this court or any court is permitted to do. On my first point, the decision below is in error and requires reversal because it is contrary to the plain language of the Public Records Act insofar as it concludes that the Public Records Act does not apply to Elon Campus Police because it is not a public law enforcement agency. This is directly contrary to the plain language of the Act because pursuant to the language of the Act, whether the Act applies depends not on whether it's a public law enforcement agency, but rather on whether Elon Campus Police is an agency of North Carolina government or its subdivisions. The mandate of the rule is found in Chapter 132-1b, and it declares the public records and public information compiled by the agencies of North Carolina government or its subdivisions are the property of the people. That is the umbrella rule. This is the starting point of the analysis. And quite frankly, neither court below specifically addressed the question of agency, although it is implied. As to the decision of the Court of Appeals, it states the general rule and then jumps to the analysis of the public law enforcement agency. Well, you can't reach the public law enforcement agency without first concluding that an entity is an agency of the state. And so to the extent that the decision below implies that the Elon Campus Police is in fact an agency, we would agree. But there are consequences that attach to such an implication, because pursuant to the plain language of the Act, if you're an agency of the state, then information that is public records that's in its possession is the property of the people. That is clear statutory language. It's not maybe the public of the people, should be the public of the people. The plain language of the statute is the public records and public information compiled by the agency of North Carolina government or its subdivisions are the property of the people.
Let me interrupt just a second. I know I'm going forward in your argument, but the first question I've got is 132-1.4 sets out very plainly the records that are available to the public from law enforcement. Are you in any way trying to expand the traditional view of that, or are you simply saying Elon, by the
not seeking to expand those items set forth in 1.4.
So would you, I read with interest all the amici briefs. Certainly, when I looked at some of the law enforcement concerns, it seemed to be that they were afraid that there was some attempt to expand 132-1.4, and you're stating that's not the intent of this lawsuit.
That's correct, Your Honor. That is not the intent of this lawsuit. And to be absolutely clear, we are not seeking to be able to reach the records of the university as a whole. We are only seeking to reach the records of this entity, the campus police, which happens to be an entity existing and authorized by power of the state conferred upon it by the legislature that happens to reside within the confines of this particular private institution.
Do you know of any situation in North Carolina where the power to arrest is given to some entity that is not considered public or governmental? In other words, can a private entity arrest somebody and bring them into court?
Under 74E, the Company Police Act, yes, they can.
Are they acting as a private entity, or are they acting as a governmental entity? And this gets, quite frankly, to the Davidson College case. As you look at the Davidson College case, how would you characterize the rationale of this court that Davidson College Police Department has the right to arrest and bring people into court, and that does not violate any constitutional provision?
And I assume Your Honor is referring to the decision in State versus Yenser. Is that correct? Okay. And we would say Yenser applies here as it pertains to the starting point of the analysis. First, whether it's an agency. And this court undertook great analysis of the character of the agency, which in the Court of Appeals in News and Observer versus Wake County Hospital Systems, a case that this court declined further review, said that the nature of the relationship between the entity and the government was dispositive of whether that entity was an agency. And so here, in Yenser, this court said that the Davidson College campus police was an entity that had limited ability to, conduct, to supervise its own activities, but that the power, the police power remained in the hands of the state. That's specifically what this court said in Yenser. And so we would apply that analysis applies equally here to, again, following the framework for public records analysis set forth in Chapter 132, that is the starting point. The Elon Campus Police and organizations organized under 74G are an agency for purposes of the Public Records Act. And so then following down, then you have to go to the next step. So that's the umbrella rule. All the information in the possession of the agency is public records, absent a specific statutory exemption or exception. So you kind of have to answer the first question before you get to the second question. So the exemption that we're talking about here is the exemption for criminal records of public law enforcement agencies. And then here, this is where the Court of Appeals jumped into the analysis. And so we have to jump down. We have the statute itself provides definitions of, okay, so the exempted from the Public Records Act. So if we have the umbrella rule, you're a public record. Now we look for exemptions. The exemption we're talking about, 132-1.4a, records of criminal investigations conducted by public law enforcement agencies are not public records. So that would take that section of records out of the realm of public records. And so the statute defines some of those terms. So the public law enforcement agency is defined at 132-1.4b3. And I know the court can read, but the definition is a municipal police department, a county police department, a sheriff's department, a company police agency commissioned by the Attorney General pursuant to 74E, and any state or local agency, force, department, or unit responsible for investigating, preventing, or solving violations of the law. And that last phrase there, violations of the law, is also a term defined by the statute. And That's defined at 132-1.4b4. And violations of the law is defined as crimes and offenses that are prosecutable in the criminal courts in this state or the United States, and infractions as defined in Chapter 14. So I guess to directly answer your question, Your Honor, if an entity or a person commissioned by statute has the power of arrest, then yes, all the records related to that would become public records as defined by the statute here, the plain language of the statute here. So, as I indicated, we would say that the first question depends on agency. We've talked about that, and we contend that it is. The decision below implies that it is without conducting any actual analysis of that. So then, we look to the exceptions. And before I forget to, talk about this, this court has previously said the Public Records Act is to be construed liberally in favor of disclosure, while the exceptions and exemptions are to be construed narrowly. So to the extent that we're looking now at exemptions from the records, these are to be construed very narrowly. So exempted from public records are the records of criminal records conducted by public law enforcement agencies. And this seems to be the crux of the fight between at issue here, because if it's a public law enforcement agency, then those records come out, but then there's an exception to the exemption that is found at 132-1.4c that says, notwithstanding the provisions of this section, unless otherwise prohibited by law, the following information shall be public records within the meaning of the Act, and then it sets forth a laundry list of items that are, in fact, and it shall be mandatory statutory language, not discretionary, that shall be public records within the meaning of the Act. And included in that laundry list is item 3, the circumstances surrounding an arrest, including the time and place of the arrest, whether the arrest involved resistance, possession or use of a weapon, pursuit, and a description of any item seized in connection with the arrest. So,
let me jump in again. Another question, not related to what you just said, sorry. Do you care where the material comes from? I mean, it seems like to me you've got two parties. One, the state attorney general saying, we don't keep up with those kinds of records. We do the licensing. We're sure that the various universities are in compliance. We don't keep up with their day-to-day records. Right? The university, on the other hand, saying, yeah, we got the records, but we don't want to give them to you because we're a university, we're not public. Right? As long as this court were to find that it's a public record, do you care whether or not it comes to the attorney general? Is that a piece you need in this case?
not specifically, Your Honor. I would say it's a distinction without a difference. I mean, if it's public record, we would say it is required, it's mandatory that it be disclosed, regardless of its source. Whether it lives with the campus police unit itself, or whether that information lives with the attorney general, its source, I would say, is not of, the disclosure is the key fact here. Okay. So turning back to the exemption and the exception. So the decision below concludes that the Elon Campus Police is not a public law enforcement agency and therefore not subject to the Act. But if it's an agency of the state, then its records are public record, absent an exemption. So, we would agree, for purposes of present discussion, we would contend that the Elon Campus Police is in fact a public law enforcement agency, but records in its possession are public records, and disclosure is required. And on the public law enforcement agency question, the decision below very narrowly read the definition of the public law enforcement agency found at 132-1.4b3, focusing only on the very narrow provision that the Attorney General pursuant to 74E, but yet there is no evidence that the court below performed any analysis or even considered the last phrase, and any state or local agency, force, department, or unit responsible for investigating, preventing, or solving violations of the law. To the extent, so we've got Elon Campus Police. It's an entity organized by statute that's been conferred upon very specific powers. The power of arrest, the power to arrest for felonies, misdemeanors, infractions, an entity that is required to maintain the minimum standards required for state and local law enforcement agencies. Yet, the Court of Appeals concludes that it's not a public law enforcement agency. A decision actually applying that, I'm going to call it the catch-all phrase, that last phrase that talks about, any agency. I'm going to call it the catch-all phrase. The Court of Appeals in McCormick versus Hansen undertook is a case that is instructive for this court, where it undertook to perform the analysis on that catch-all phrase and to apply it. And in McCormick, Hansen was seeking disclosure of public records from the Raleigh City's Attorney's Office. The trial court in McCormick said that the City Attorney's Office is a public law enforcement agency as defined in the Public Records Act. The Court of Appeals agreed and said because it had the responsibility for investigating, preventing, or solving violations of the law, as well as enforcement powers over misdemeanors and infractions, that it was in fact a public law enforcement agency. Well, we think that analysis applies equally here. We can't just read in narrow isolation the 74E enumeration. We have to look at the definition of public law enforcement agency as a whole in pari materia, and both as the definition and in terms of the act as a whole, to be read liberally and in favor of disclosure.
If we agree with your interpretation that the catch-all, as you call it, covers the university, the university's argued that they've turned over everything that you would be entitled to.
Well,
Is that
we would disagree, Your Honor, and quite frankly, because the case got dismissed at the 12B6 level, Ochsner had no opportunity to conduct any discovery to find out if he did in fact get everything that he was supposed to get. We would contend that he was not provided with all of the information related to the circumstances of arrest, more specifically whether there was a pursuit involved. The arrest report in the bottom part, at page 11 in the record, on the bottom of page 11, there's a place for narrative, and it adopts by reference the incident report. Not page 1 of the incident report, but the incident report. And so page 1 is what was actually produced. We don't know with certainty what's on page 2. And even if information on page 2 would contain information that is not public record and not subject to disclosure, pursuant to, I believe it's 132-1.4F, the agency is still required to produce the information while merely redacting the non-public information from it. Another potential remedy would be, if this case were to be remanded back to the trial court, could order an in-camera review. Elon could produce the information to the trial court, and the trial court could produce an in-camera review. So it would be acceptable limitations. So for the reasons that I have stated here this morning, we would contend that the decision below is an error and requires reversal. As to the arguments related to the Attorney General, I'll rest on what's in our brief. Absent any further questions from the court, I'll yield my time to Ms. Martin.
Thank you.
May it please the court, Madam Chief Justice and Associate Justices, I'm Amanda Martin, and I appear here this morning on behalf of 4 amici, the News and Observer, WREL-TV, the Daily Tar Heel, and the Alamance News. And I'm here to urge you to confirm that it is not corporate substance that determines whether an entity is covered by the North Carolina Public Records Law. This is not new territory for this court. It is merely the application of an existing principle to the context of the Public Records Law. In deciding a venue question in Coates versus Sampson County Memorial Hospital, this court ruled that even though the defendant was, quote, not a municipality in the sense of a political subdivision, such as a city or town or quasi-municipality like the county, the court found that Sampson County, quote, has delegated to defendant its authority. Defendant is, therefore, an agency of Sampson County. Our Court of Appeals has applied that concept repeatedly in the context of the Public Records Law. In News and Observer versus the Wake County Hospital System, the court said, quote, each new arrangement must be examined anew in its own context. And the court borrowed reasoning from interpretation of the Federal Freedom of Information Act and found that, quote, where substantial powers to act with respect to individuals are vested, there is administrative agency. Years later, the Court of Appeals in Chatfield versus Wilmington Housing Finance confirmed, quote, a corporate entity also may be considered an agency of local government for the purposes of our state's public records statute, and found, quote, the nature of the relationship between a corporate entity and a government is the dispositive factor. The police department at Elon is performing a quintessential governmental function that is clearly set out in the Campus Police Act itself. If you look at the statute at 74G, it says in the policy and scope that the purpose of this chapter is to protect the safety and welfare of students, faculty, and staff in institutions of higher education. Further down at B6, the statute answers our question. We don't have to interpret, because the statute says at B6, the principal state power conferred on campus police by this chapter is the power of arrest. The statute says state power with a capital S. This is an agency that is exercising governmental authority. And our cases routinely have said that the application of the Public Records Law is to provide transparency and open understanding and access to governmental functions. And there can be little question here that the police department at Elon University is carrying out a governmental function. In the 1700s, Voltaire wrote, "With great power comes great responsibility." That is no less true today. Our government has ceded its police power on Elon campus to the Elon Police Department. With that power comes the transparency that is found in 132-1.4, subsection C. The law leaves no other conclusion, and why would we want it any different way? The defendants in this case have suggested that such an interpretation would open up the university as a whole, but that is not the case. What is sought here is limited access to information and records that are contained within an agency that is exercising governmental functions. And there is no reason that the list of horribles that are brought before this court should be persuasive when all that the petitioner is seeking here is the same information that he would be entitled to receive were this a transgression or crime that took place on the streets of Elon, the city, rather than Elon, the campus. The statute is clear what powers the police department is exercising, and surely our governmental power carries with it the right to see and supervise and understand how that authority is being exercised. For this reason, we urge this court to overturn the rulings below and find that the Elon University Police Department is a public agency subject to the Public Records Law. Unless you have any questions, I'll leave the remaining time to my co-counsel.
Thank you, Ms. Martin.
Thank you.
We'll hear from Matt Elliott.
May it please the court, I'm Chris Jones. I'm with the Womble Carlisle firm here in Wake County, and I represent Elon University in this appeal. I'm here today with my co-counsel and colleague, David Elliott, who's an assistant attorney general who is representing the Attorney General's office. And we are joined on brief by the North Carolina Sheriff's Association, the Association of Chiefs of Police, the North Carolina Association of Chiefs of Police, and the North Carolina Campus Law Enforcement Administration, as well as the North Carolina Independent Colleges and Universities, Inc., who are all amici in this matter. I would like to reserve, or Mr. Elliott and I have split the time this morning so that Elon's portion of the argument will be 20 minutes and the Attorney General's time will be 10 minutes, if that pleases the court. The issues before the court are narrow, but they are important. And they're important because they extend beyond just Elon University, and they extend beyond just private university law enforcement. They extend to every law enforcement entity in the state of North Carolina. One of the issues does. And the other issue extends to every private or independent college or university in the state. This case gets to this body in a somewhat unusual way, which is to say that at the trial court, there was a threshold issue that the trial court judge determined, which was whether or not Elon University had complied with any obligation that it may be required by a public law enforcement agency, without regard to whether it was a public law enforcement agency. And the trial court determined that Elon University had complied with any obligation that may exist under the Public Records Act.
Where is that in the record?
It is in the, if you look in the transcript, which I believe is in the record from the trial court proceeding, you'll find it there, Your Honor. And I can't point you to the specific specific page, but that commentary was included by the trial court at the hearing.
I thought that we're up here on 12b-6. That's very different than a 12b-6. I mean, on one hand, you've asked for the material, it's been complied, it's been given. It's very different than you failed to state any kind of claim upon relief can be granted.
The trial court's ruling was you failed to state a claim because the Public Records Act, the obligations of a public law enforcement agency under the Public Records Act are limited. And they are limited in all respects to essentially what the UNC School of Government has concluded, which is that page 1 of the investigation report and the arrest report, if those documents are provided in response to a request, they actually include more information than is required under the Public Records Act.
Well, certainly, you heard counsel, as I did, say that she wasn't seeking to expand the information that was required to be disclosed. It's their allegation that apparently this particular incident included flight or resistance and or pursuit, and that information was not disclosed, even though 132-1.43 says it should be.
Their allegation, I think more to put a finer point on it, is to say that the documents that they received from Elon University did not contain an affirmative statement with respect to whether pursuit occurred or not. And as this court knows, in any Public Records Act case, there is no obligation to create information. That information is either within the public records or it isn't in the public records. In this particular instance, we believe that it is implicit from the answer to the question is implicit from both the charge and from the various boxes that were checked and or left unchecked by the arresting officer. And so we do believe that what appellant really sees is a significant expansion, not a small expansion, a significant expansion of the obligation of public law enforcement agencies under the Public Records Act.
Well, I'd say this court says, okay, Elon, with all due respect, you exercise the power of arrest under Yinser. You can't have it both ways. Either you're public, if you're private. We've got the other First Amendment issues we've got to deal with. We said you've got the power to arrest. Now,
which is what I understood appellant to be urging this court to rule. They are
Just say the law enforcement agency.
agency of the state of North Carolina. If you rule that, then it will not be just like any other public law enforcement agency. It will be the only public law enforcement agency in the state of North Carolina that isn't enumerated within the definition of public law enforcement agency in the statute. It will be set out special and different from everyone else. The second point I would make is that while this court clearly in Yenser indicated that police power was conferred upon the Davidson College campus police, that delegation is not dispositive of whether or not the Davidson College campus police becomes a public law enforcement agency or an agency of the state of North Carolina, any more than it is dispositive that when the courts in the state of North Carolina delegate upon me as a practicing attorney that's licensed in this state the power to subpoena, to command individuals to appear at certain places and certain times for certain proceedings, to command third parties that aren't involved in litigation to produce otherwise non-public documents. That does not make me a public agent of the state of North Carolina. It does not render those documents that are received from the subpoena public in any nature, in any way.
What power do you have to enforce that subpoena?
I go to the courts to enforce, but the enforcement procedures are the same enforcement procedures that are undertaken if it's a court issued subpoena.
Granted, as an attorney, you have special responsibilities, but you don't have any power to enforce. We have granted Elon University police officers the power to arrest, the power to conduct searches and to seize. These are very special and uniquely governmental activities. I don't see how that is the same comparison with an attorney being able to subpoena. Clearly, the General Assembly intended for law enforcement activities to be protected from general disclosure under the Public Records Act. But with regard to simply requiring the same information with regard to anybody else in the state of North Carolina who's arrested, to have that information provided, I don't see how that's onerous.
Well, I'm sorry, did you say you don't see how it's onerous? Justice Newby, I don't think the question of whether it's onerous or not is necessarily the right question to ask. The issue here is whether, and what appellant is urging the court to do, is to judicially expand the public law enforcement agency definition within the Public Records Act. Now, they have argued that you don't have to get there. They've said that Elon University is merely an agency of the state of North Carolina. And I would argue that even a cursory reading of the Public Records Act would reveal that you do have to get there. Because unless you are a public law enforcement agency, all criminal records or records of criminal investigations are not public.
Well, give us your reading then of 132-1.4B3, and looking at subparts 3 and 4. It seemed to me that you would have to give a very special governmental interpretation of unit responsible for investigating, preventing, or solving violations of the law.
See, when appellant raises that argument, they are ignoring the modifying language at the beginning of that phrase, which is important modifying language, state or local. And let me walk through because I would propose to the court that we're in this particular instance, with respect to the question of whether Elon University is a public law enforcement agency, it isn't so much a question of interpreting the statute as just applying it. Elon University's campus police department is not a sheriff's department. It's not a company police department commissioned by the Company Police Act. It is not a municipal police department. It is not a county police department. The appellant hasn't even argued otherwise. That leaves the last phrase. So the question that you ask is, Well, then is Elon University a state or local agency, force, department, or unit responsible for investigating, preventing, or solving violations of law? And the answer to that is clearly no. And the appellant admits it as such in its second or third paragraph in its complaint, wherein it admits that Elon University is a private university. And it is the privateness of Elon University, the non-state characteristics of Elon University, that take it out of that subsection. It is precisely that reason that company police that are commissioned under the Company Police Act have to be specifically included in that subsection. Otherwise, there would be no need to have that special inclusion. They would just fall under the same subsection that Your Honor points out. And I would add that the Campus Police Act itself, in it, the legislature contemplates that there are campus police agencies that are non-public entities. If you look at 74G3 and subsection C, the legislature indicates a campus police agency that is a non-public entity must maintain the liability insurance policy certificate of self-insurance. And it goes on to talk about a requirement that non-public campus police entities retain insurance coverage. And there are reasons for that. Campus police are different than public law enforcement agencies. Campus police are even different than company law enforcement agencies, and I'll explain why I think that's true. Company police that are commissioned under the Company Police Act, they don't have reporting requirements the way campus police do. They're not subject to FERPA the way campus police are, which is a federal privacy law. They're not. They don't report under the Clery Act the way campus police do. Now, I am not standing here to argue to you that reporting under the Clery Act is the same as access to public records. I am simply saying that there are aspects of campus university police that are unique, and they are different than company police that are commissioned under the Company Police Act, and they are certainly different than public law enforcement agencies such as sheriff's departments and county police departments.
How do you square your interpretation with this court's decision in Yenser?
Well, as I said, I don't find Yenser to be instructive, particularly, and the reason is because the court only went so far in Yenser and this requires a little bit of inference, but the court only went so far in Yenser as to conclude that there was state action involved.
Well, as a matter of fact, I think we went a bit beyond that. Quoting page 303 of the opinion, the statute grants only limited supervisory powers to Davidson College, while ultimate control of the police power, which the individual officers alone exercise, remains in the hands of the state. That's pretty strong language to say that what the officer is doing is, in fact, state action.
What I understood that to mean when I read Yenser was not unlike, or was essentially drawn, I thought, from 74G2B and then subsections 1 through 9. I'm sorry, I just quoted the wrong section. 74G4, excuse me, sections 1 through 9, which discusses the powers of the Attorney General vis-a-vis commissioned campus police officers under the Campus Police Act. And what I really understood the court to be saying is ultimately, if we've got a rogue department, the Attorney General has the power to pull a commission. I don't understand the court to have found in Yenser that the Attorney General was in any way involved in the day-to-day activities or oversight or supervision of officers at Davidson University or any other private universities in the state of North Carolina where their campus police is concerned. I don't believe that the powers conferred upon the Attorney General in 74 so the power, the police power that is, there is a police power that is conferred. This court without question recognizes that in Yenser. But that is a different issue than whether or not the definition of public law enforcement agency as it is set out in the Public Records Act creates in Elon University either a public agency, as appellant has argued, or a public law enforcement agency, which we would argue is the more correct analysis to walk through, where when a plain reading of that act reveals that it doesn't, and that the question of whether it should, which is a large volume of the briefing from appellant and appellant's amici, is the question of whether it should. That question we urge the court to refer to the legislature as being within its unique province. In the event that there are important policy issues being raised in this case, we believe that this court has an opportunity to urge the legislature to take action. And there, the issues of uniqueness associated with private universities that are commissioned under the Campus Police Act can be properly debated. All of them can be considered. And the elected representatives can then determine whether the legislature intended that in 2005, when it created the Campus Police Act, that the Campus Police Act would somehow inferentially be included within the specific definition of the Public Records Act. The last guiding principle that I would add is this. Appellant has argued that the Public Records Act is generally read expansively. And that's true. But that is also before you get to the criminal records exception. It's because when you're dealing with criminal records, you start from an entirely different posture. You start from the posture that those records aren't public. They are specifically not public. So instead of starting from the perspective that they are, as you do with a Public Records Act that goes to the Department of Health and Human Services or the Department of Natural Resources, you must start from the posture that they are not public documents. And then we look to conclude why they might be. And the only way to get there is to walk down through and identify whether the agency that is at issue is a public law enforcement agency. If it is not, then we concur with the Court of Appeals. That is where the analysis stops. If it is a public law enforcement agency, then you walk on down to determine whether or not the information that was provided is sufficient to meet the obligations under the Public Records Act. And those obligations are quite specific. And they're specific for a reason. The appellant argues that the information that Elon voluntarily produced was not expansive enough on the issue of the circumstances of the arrest. That there might be more information. And that is a dangerous road to go down when you begin from the perspective that these records as a whole are not public. Because if there might be more information, then what Professor Lawrence and the UNC School of Government says is sufficient, and what they're advising every public law enforcement agency in the state of North Carolina is sufficient, I might add, then you get into a situation in which you are looking for more circumstances and more circumstances of the arrest. And the exception then swallows the rule. So, Your Honor, for those reasons, for the reasons that are included in our amicus briefs, the amicus briefs that were filed, and for the reasons articulated here, we would ask the court affirm the Court of Appeals decision and or affirm the Court of Appeals decision on other grounds, those being the ones that were ordered in the
Elliott. I'm with the Attorney General's office, and it's my privilege to represent the Attorney General. There was no argument made. The appellant rested on the brief, and so I will attempt to be brief in addressing the one issue as it relates to the Attorney General. That issue can be found in the petition for discretionary review that sought permission from this court to address whether or not the Attorney General is the custodian of the records of the Campus Police Program. As you've heard, there is 74G is the Campus Police Act, and it establishes, one of the first things it does is it creates the Campus Police Program. That program has two primary functions. It certifies police agencies, and it commissions the officers. Within that act, the legislature was careful to designate that the Attorney General is custodian of records of the Campus Police Program. Elon's police department is a police agency. Had the legislature intended for the Attorney General to be the custodian of the records at issue here, it would have stated the Attorney General is custodian of records of the Campus Police Agency. That's not what they said. If we look at the appellant's brief on page 29, since the argument was that they will rest on the brief, there is no argument and no authority cited for the Attorney General being the custodian of records of the Campus Police Agency. And so we would contend that that issue has been abandoned, and based upon the rationale of the Court of Appeals, the statute is clear on its face. The Attorney General is not custodian of records of the agency. The Attorney General is custodian of program records, and this court should uphold the decision of the Court of Appeals. On page 29 of the brief, rather than arguing the one issue that's before this court, the appellant has attempted to switch horses. Instead of arguing that the Attorney General is custodian of Campus Police Program records, the brief argues that the Attorney General is custodian of records of the Campus Police Agency. And what they say specifically in the brief is that the Court of Appeals' decision is too narrow, that their complaint was not based upon 74G5 exclusively. But if you go look at the record, if you look at what was argued at the Court of Appeals, there was only one issue argued. And the only issue argued at the Court of Appeals was that the Attorney General was custodian of the records of records maintained by the Elon Police Department pursuant to 74G5. That's the only argument made by the appellant at the Court of Appeals. The Court of Appeals decision tracked that argument exactly and held that 74G5, the only statutory basis argued before the Court of Appeals, did not hold the Attorney General as custodian of those records. We would submit that that was not presented to this court in the petition for discretionary review. It's not properly before this court, and that those arguments should not allow the appellant to prevail. We ask this court to uphold the decision of the Court of Appeals, finding that the Attorney General is not custodian of the records at issue here. The court has no further questions. Thank you for this opportunity.
Thank you, Mr. Nick. Vote.
May it please the court, I'm going to briefly respond to some of the arguments made by counsel for Elon in his argument. The argument that the information that they gave Ochsner is more than what is required does not relieve them of their obligation to give them what is required. If the statute requires them to give A, B, and C, and they gave A, B, D, E, and F, it does not relieve them of their obligation to give C, which is exactly what happened here. Counsel for Elon cites to no record reference as to where information regarding pursuit exists in the information that was provided. What information related to pursuit shall be. Mandatory statutory language, shall be public record, and as such it must be disclosed. And I would also point out here that in the general rule of 132-1B, public information and public records both are the property of the people. It doesn't matter in what form it lives. If what Elon says is true, then no police department would write down any information. If it's information or records, it's the property of the people and requires disclosure.
Well, what if there wasn't any pursuit in this case?
Well, that's exactly what Ochsner's trying to find out, and he's entitled to know if it was.
Does the form itself need to have a box on there that no pursuit, or in every case are the police required to affirm
addition of a checkbox on a form, on these pre-printed forms, would be a good starting point. But, leaving it to the discretion of the agency to fill it in, if it's mandatory public information and required to be disclosed, that's not discretionary. There needs to be a place. James Madison said, "The essence of government is power, and power lodged as it must be in human hands will ever be liable to abuse." That's exactly what we're here talking about today, the Public Records Act, which this court has said by enacting it, the legislature intended to provide, as a general rule, the public would have liberal access to its public records. Transparency in government is certainly of tantamount importance, plays a vital role in the ability of our citizens of this state to keep themselves informed and to hold its public officials accountable.
I can respond to the argument that, the plaintiff is asking this court to expand the statutory definition, which probably predated, quite frankly, the Campus Police Act. Nonetheless, it is what it is, and that if we read state or local agency, force, department, or unit responsible for investigating, preventing, or solving violations of the law to include campus police under 74G, we have expanded what the legislature clearly has previously said.
Yes, Your Honor, I would respond to that argument by saying we're not seeking to expand its definition. The legislature, in its plain language, wrote an expansive definition on its own.
Well, the legislature could have gone back and amended this statute. Granted, when they tinker with things, they don't always know what to amend, but they could have put 74E, and then they could have put in 74G.
Yes, Your Honor, would contend that they didn't need to. And you mentioned some historical references. In 1992 is when 74E was enacted, which repealed the earlier statute. And then if you look at the statutory history of the definition of public law enforcement agency, that was enacted in 1993. So 74E was the provision that existed at the time it was written. And so then when they came back and passed 74G in 2005, quite frankly, they didn't need to come back and revisit the definition of public law enforcement agency because of the expansive definition that existed already encompassed the very powers that were conferred upon Elon, the very specific power of arrest. I see that my time has expired, so without further questions, we would urge this court to reverse the decision below. Thank you.
Thank you. Thank you. Madam Clerk?
All rise. Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until 9:30 tomorrow morning. God save the state and this honorable court.